in regards to the zone of reasonableness docket. And I'd like to introduce ourselves. I am Leo Asuncion, Chair of the Commission, and with me is Commissioner Naomi Kuae and Commissioner Colin Yost. Today's hearing is being live streamed via the Commission's YouTube channel. It is also being recorded, and we do have a court reporter here. So I ask all of you, when you are speaking, make sure, first of all, your mic is turned on. When you see the green light, it's live, it's hot. And also speak very clearly and succinctly for our court reporter. She will stop you if she didn't get something. So make sure that you do that so that we can dispose of those items quickly. This afternoon, the Commission is holding this hearing on docket number 2022-0063. The purpose of this hearing is for the Commission to take oral arguments on the matter and to ask questions of those appearing this afternoon. The Commission will not be answering any questions. The scope of the hearing is limited to the issues outlined in order number 38666, which was filed on October 21, 2022. Since then, the Commission has received written briefs from the Western Motor Tariff Bureau, the Division of Consumer Advocacy, and Roberts Hawaii. Just some ground rules for today's hearing. The parties and individual motor carriers who have submitted written briefs will be given 10 minutes to present their arguments. You can summarize or you can also stand on your written briefs. And we will go in this order. Western Motor Tariff Bureau first, the Consumer Advocate next, and Roberts Hawaii. And then the Commission will then hear rebuttals, if any, in the same order for up to 10 minutes from each presenter. After the rebuttal, the Commission will then ask its questions of the parties and the participants. And if time permits, which I think we will have time, we will take comments from the public. So those members of the public that wish to provide comment on this matter, there's a sign-up sheet on the table to my left here against the wall. Make sure you sign in so that we'll have a list that we can go through and call you up to provide your comments. After the hearing, the public may submit comments in writing to the Commission by email or by regular mail. Please reference docket number 2022-0063. And you can email the comments to puc.comments@hawaii.gov, or you can mail them to the PUC at 465 South King Street, room 103, Honolulu, Hawaii, 96813. And there's papers posted around the room for those addresses for the public, and I think it's also being shown right now on the YouTube stream for that information. Lastly, if you do testify this afternoon, at the beginning of your testimony, please identify yourself, state whether you are testifying on behalf of an organization or as an individual, state your position and argument to the following questions. And these are from the issues that were noted, or questions that were noted in the order. One, does the PUC have jurisdiction over the motor carrier's decision to provide discounts and commissions to travel agents and or independent travelers? Please cite to applicable laws in your explanation. Number two, if the Commission has jurisdiction, what are the specific ranges and restrictions on discounts and commissions that the Commission should approve and regulate? Three, how will the discounts and commissions offered to travel agents impact the motor carrier's tariff rates? Four, when the motor carrier leaves a tariff bureau or cancels a tariff, does the base rate from the canceled tariff transfer to the subsequent tariff filing is this the subject is this subject matter within the scope of issues being addressed in this docket? And 5, should the current temporary zone of reasonableness in the range of plus or minus 15% be extended for an additional year? With that, we will begin this public hearing, and we'll start with Western Motor Tariff Bureau. Okay.
Good afternoon, Commissioners.
Thank you, Mr. Kuniyuki. Turn now to the consumer advocate.
Good afternoon, Chair, Commissioners, Commission staff. My name is Scott Boone. I represent the Division of Consumer Advocacy. With me from the division are Reen Kamita and Dean Nishina. And I'd like to focus opening remarks just on the issue of the issues that we weighed in on. The one that appears to be in dispute is issue number 2, and specifically whether or not the Commission should provide any sort of guidance as far as the specific ranges or restrictions on discounts and commissions. There appears to be consensus that the commission does have jurisdiction as to issue number 1. And then with respect to issue number 5, there again appears to be consensus among the parties that the commission can extend the 15% zone of reasonableness for another year. So with respect to issue 2, I want to pick up on something that WMTB just stated, which is that, it does depend on the exact situation for each registered entity, and we agree with that. I think our position is most succinctly stated on pages 9 and 10 of our response to the written briefs. And basically, there we outline, what the commission should be looking for on a case-by-case basis. And because it needs to be handled in that manner, it's our position that there's really nothing that the commission needs to provide as far as guidance or further orders in this proceeding. And with that, I'll close and open up for any questions.
Thank you, Mr. Boone. Mr. Fun, Robert Hawaii.
Yeah, good afternoon. Good afternoon, Chair Asuncion and commissioners. My name is Roy Fund. I'm president, CEO of our 2 regulated entities, Roberts Tours and Transportation and Carry All Inc. I'm just going to kind of summarize. I want to summarize my testimony. From the perspective of we're the only really operating carrier that's provided input, and the perspective of my testimony really is tied to practical and operational aspects of our business and the transportation industry. So kind of going back into like some history, I was trying to look at when that Motor Carrier Act was actually put in place, Chapter 271. And it seems like, it's at least like 60 years old. And when it was put into place, I think things were a lot different from operating standpoint in the industry. Way back then, there was no competing transportation services, like Ubers and Lyfts. And, there was far less vehicles available on the road. You didn't have ride sharing. Public transportation systems were far less developed. So over time, there's been a huge increase in available transportation options, mobility options where people have different means of getting around. The PUC does regulate the commercial transportation side, and I think part of it is, definitely in place, and, whether it's, the safety aspects and making sure that people have insurance and that type of thing. The role of the PUC, and I guess this is where I wanted to kind of focus in on some of the things that maybe should be considered as we look at the issues that are part of this docket. So maybe about 20 years ago, the PUC effectively deregulated entry into the motor carrier side, because in the past, prior to that, when we had interventions, meaning that if a company wanted to get a bus license, then some or all of the existing carriers would intervene and, kind of question that whole process. That was about, that practice stopped about 20 years ago. Before that, we would have hearings over a week long just on whether somebody could come in and get a bus license, and the PUC would go through those hearings, and there was the time period could take up to 2 years for the thing to go through. But since the PUC stopped basically does not allow interventions, the entry into the industry is pretty much deregulated. So, today we have over 1,000 passenger carriers, and there's over 500 property carriers. So there's a lot of companies out there. Then the tariff issue, so you got tariffs, and Western Motor Tariff is probably the largest tariff organization. We were members of it for quite a while, quite a number of years. But, in the 30 plus years I've been in business, the tariffs are basically still the same. And if anybody really looks at the tariff document, it's kind of like a hodgepodge because you got gross rates, you got net rates, you got rates that are for old equipment, new equipment, you got commissionable rates, non-commissionable rates. I mean, there's a wide variety of rates, and I think even they mentioned that there's many different companies that are, filing different rate structures. So, there's commission structures that are tiered, it's all over the place, basically. That's the bottom line. The enforcement side, the PUC does try to enforce the rules, regulations that are in place. But, there are numerous vehicles out there that, that are running around that are not PUC regulated. You can see them out there on the road with no PUC stickers, and, they're carrying people around, going to the tour stops. So there's definitely that aspect. When you get into like the insurance, the rates and everything, there's certain like safety things. Definitely, I think the PUC has a need to do and be in place on. And you talk about the support on the 15% increase for the zone of reasonableness. I think that's, great because it does, allow the various different types of carriers the option of increasing rates depending upon their structure. And that's kind of one of the things too that's important, is that each company has different structures, different needs. Like in general, our rates are probably the higher in the industry because we do have a larger organization. We're an employee-owned company, and we've got to try to run a profitable, safe organization. So that's an important factor of what we're looking at and what we want to do. And the need to have that flexibility, to increase the rates if we need to. And we don't do every single service out there. We'll selectively look at what we think makes the best sense for us, and then we just operate it in those areas. Let's see. Yeah, and I think, one of the other things that, that's not even part of this is that in the environment today, you have a lot of community resistance to commercial transportation, bringing people into certain areas. So you see it a lot in the communities where they don't want commercial vehicles entering, whether it's, the beaches or certain neighborhoods. There's a lot of, backlash against commercial transportation, bringing in people into different areas. And what's not really fair is that, there's certain other providers, that's these commodity service providers like, the Ubers, the Lyfts, taxis, they can go in and, drop off and pick up people, but it's restricted on the commercial transportation side. So there's a lot of, these associated headwinds against the regulated companies by themselves. And when the counties and everyone sets up the restrictions, whether it's to beaches or different areas, it always comes out to who's restricted is the PUC commercial transportation companies. So we're at everyone is at a disadvantage by being a PUC operated company. Let's see. Another area too is, which I think is important, is that as a company, we're trying to be progressive and look at how we can expand into the battery vehicles, electric vehicles, even looking at hydrogen. And so we have, as an example, 3 electric motor coaches that were supposed to come in at the beginning of the year, but are now probably delayed a few months because of supply chain issues. But we had to come up with a rate on that, as this is a practical example. So we kind of just calculated out that it would be 20% higher than our standard diesel bus rate. But say coming in the future, what if our cost structure is a lot higher? Then, how do we make adjustments for that? Because you got the vehicle costs and you got the infrastructure costs, and all of those things are kind of unknown in terms of, being the first ones out there in any bigger way to implement that. I think that's where we would want to work with the PUC or someone to, make sure we have flexibility going forward as we try to move into these different areas and try to be, a lead in it. But sometimes, it can be, quite expensive, a lot of costs involved. And how we work that through the system, I think, is going to be important going forward. So I think that's another consideration in terms of allowing flexibility in what we do. Yeah, the one thing I think I wanted to touch on with the Western Motor Tariffs position, if I can cover it now, was that, it seemed like they were more concerned about, or certain members were more concerned about trying to determine what our rate structure is rather than them focusing on what their own business model and what they should be doing. They shouldn't be like keying off of like what we're doing and trying to determine what our rate structure is. I mean, that just seems to be the wrong perspective. And if they want to limit their members' flexibility by trying to tie in set commission structures, to me that should be their decision. But we shouldn't be, handicapping everybody else with those same rules that they want to play by. And so I think, like in summary, I hope that my testimony did provide some insight into the operational aspects of that we're dealing with. And then as the world is changing with new ways of mobility, new vehicles, technology, the competition, we need to, as a regulated business, have the flexibility, so we can compete going forward. Thank you.
Thank you, Mr. Fung. We will go into is it off because it's not working, or okay, Western's mic is off, perhaps. Okay. Okay, let's go into any rebuttal by any of the parties on what you heard from the others. And we'll start with Western Motor if you guys have any.
Basically, discussing what Royce has brought up, they argue that entry into the industry is unregulated. That doesn't mean the industry is unregulated, because once the common carriers come in, they have to file tariffs. So they are being regulated. And as far as the other issues about that there are common carriers running around out there that are not following the rules or whatever, that's basically an enforcement problem. We also agree that there is a lot of people that are sort of cheating at the edges, but that's up to the commission to properly enforce the rules. It's not possible to have a rule that people ignore, because pretty soon it's just the Wild West. So that's not addressed by having complete flexibility in what you charge. And it's not so much that our members want to know what Roberts is charging, but it's part of the structure that when you file a tariff, you let everyone know, the general public as well as your competitors know what you're actually charging, what the actual rate is. And if you can discount that 100%, it's hidden. And that's the whole point. It's not fair and just and non-discriminatory if one carrier can just do whatever they want, which means that if Roberts is allowed to do that, then every carrier should be allowed to do that. And what do you have then? The Wild West. Then everybody will file rates and then not even listen to their own rate by saying we're discounting it. Now, discounts mean it can only go down, but still. And as far as they're saying that they're pioneers in the industry, well, that's good. because if they file a tariff and it doesn't work, they can always go in and amend it. There's nothing stopping them, from giving notice and going and amending it if the tariff does not meet their needs. Because part of it is what's fair and just to the carrier itself. And you can look at, what it's actually costing them, what the demand is, how it affects the public. And that's part of how the tariff system is supposed to work. And they could even do this on an emergency basis. They don't have to give, 30 days notice. They can ask the commission to give them, an immediate relief. And we certainly wouldn't oppose that kind of situation. So that's basically our situation. And we were waiting to hear from the HTA, frankly, see what their position is on all this.
Mr. Boone, any rebuttal?
Yeah, I just want to comment on the perspective that it's almost like a slippery slope argument that's being made, where if we allow discounted, a range of discounts for one carrier, then it's just going to open up the floodgates. But I think we have to take a perspective of what it is the commission's trying to regulate here. And I think the commission hit the nail on the head with its opening order, which is to maintain a competitive and efficient market. And going back to that page 9 and 10 of our response, the issue isn't the fact that there's a range of discounted rates. It's whether or not that range, as far as it redounds down to a net price, is coming in under the regulated entity's marginal costs. Because if it is, then there could be kind of adverse impacts. And we laid out 3 of those. One is that other customers are going to be paying higher rates, but in a competitive market, they can, seek services elsewhere from a competitor. So that's really not an issue for this commission. The other is whether or not that entity could go under because it's not able to cover its operating expenses through revenues. But again, if an individual carrier goes out of business, it's a competitive market. That need will get backfilled by other competitors and or new entrants into the market. And then the last issue, which we do agree with WMTB on, is whether or not, excuse me, there's anti-competitive practices going on. But in this case, there's been no evidence presented where, as a general rule, the commission could apply something. And again, we would just emphasize that to address that specific issue, it needs to be handled on a case-by-case basis with evidence through an adversarial process.
Thank you, Mr. Boone. Mr. Fun, any rebuttal?
Well, just a couple comments is that when you do look at that need for flexibility, every company, again, is different. They have different cost structures, different reasons why they're in business, in existence. It seems like there's a big fear that somebody, whether it's us or somebody else, is going to go out there and, significantly undercut the market. But there's so many cheaper, less cost options out there already. You take the Uber and the Lyft, and their flexibility with pricing. They have surge pricing, demand pricing, so they can go all over the place. And so when you are looking at that as a transportation competitor, in the point-to-point transfer business or that segment, I don't think anybody can really beat them, because their cost structure is so low. They're running on their own, like, individual cars, and they've got independent contractors. They don't pay the benefits that companies have to pay. So you talk about competition, it's not amongst the regulated companies, it's these other transportation service providers that are really out there with the lower cost model. So, and I think, there's this misunderstanding of where that cost model is coming from, the cost competition. It's not within the industry. Yeah, there's competition within the industry, but then your bottom line low-cost operators are these other third-party operators. Same thing when Amazon comes in with their contract delivery services, when they open up their distribution facility, they'll hire contract people who are going to provide their package delivery on a contract basis. So, again, is that a regulated business? Not the way they really run it. So that's really where the competition is coming from. And I think what our position is, where we can have the flexibility to compete if we can compete, but if not, then, that's a segment that we're going to back out of. So that's kind of like, I think, what my comments are related to that. Thank you.
Thank you, Mr. Fun. Okay, we'll now go to any of the commissioners if they have questions, and we'll start with Commissioner Yost.
Thank you, Chair. I think I'll start with you, Mr. Fun, and trying to get more information. Really, the main reason why we didn't waive the hearing today is we do have questions, and we'd like to try to create a more complete record so that we can understand the issues better. And we appreciate all of the information you've already provided today, in addition to what you've given us in writing. So getting into the specifics a little bit on the commissions and discounts for Roberts specifically, can you give more detail as to how, let's start with commissions, how the commissions are actually being applied in the real world? I mean, you've got 0 to 50% in the tariff, but what's it like in the real world? I mean, are you ever giving commissions greater than 20%?
Yeah, so then there's certain volume-based companies that might get like 25 or 30%, depending on what it is. And then when you talk about like the commission structure in general, like it's like, like 20%, 10%, sometimes it's like gross depending upon, the availability of equipment. And, there's certain cases, and I don't know how familiar you are with the situation, the operating situation now, but there's a huge shortage of CDL, commercial driver licensed drivers. So that happened, after the pandemic when a lot of them retired or moved on to other positions. So there's probably, like in our business, there's more demand. So we cannot supply the drivers and the vehicles that I guess the demand is requiring. It's just impossible at this point because we're training, we trained as an example, 60 drivers, CDL drivers last year, and we're still short, more than that number statewide. So there's a huge cost to doing all of that. And so, when people are talking about discounting and all of that, you cannot do that because your cost of your operation is so significantly higher when you're out there training a regular type 3 license up through a CDL license. It could take months to do that. So, when you look at the overall discounts and structures, it's not really out there where we're flipping rates every single day or every single week. You can't do that. I mean, just from a practical standpoint, to even try to account for that is very difficult. But what it is in certain cases, we may want to provide somebody with, example, 100% discounted transportation. Say if they're requesting, it's some good customer and they may have somebody they want us to comp the transportation for. It could be a situation where we've made a mistake or we're late and we waived the charge, and so we're basically giving a 100% discount on that. So there are various other reasons why we want to make sure that we do have flexibility and that again, we're trying to be compliant with whatever tariff that we're filing.
Okay, so focusing again right now just on the commission part so we can understand that. And then I'm going to ask you questions about the discounting.
Okay.
So for commissions, who are commissions paid to? What kind of entity do you pay commissions to?
Generally, there's a commission is paid to the originator of the business. So say could be a travel agent. It could be some guy who has a group and then you don't want to bring it to you, so that the group coordinator or whatever. So, but in general, it's some kind of travel agent wholesale company.
And do you negotiate commissions separately with each travel agent, for example? Or are they all receiving the same commission?
No, it's based on, like history, type of work, and I mean, so there's numerous factors that go into it.
Okay. Let's go to discounts then. I get the comp concept or maybe a charitable donation or something like that, but is most of your discounting structured in some way? Like we've looked at other tariffs that have been filed, and some companies will say they have a 10% discount for Kama'aina or a 10% military discount. So do you have similar fixed categories of discounting?
Yeah, we have different categories. There are like discounts for various groups or type of business sources and things like of that nature. Yes.
Okay. Are there any other categories that are unusual, or I mean, can you describe how hard would it be for you to give us a complete list of all the categories of discounts?
I mean, it's possible to put together a list. Yes.
Okay.
Yeah.
And then how much of the discounting happens in those defined categories? Like more than 90%, more than 95%?
Of what
All the discounting that you do as a company?
when you talk about like for like discounts for like groups, affinity groups, or that type of thing, or
Well,
certain segments,
Yeah, I get
like
what I'm.
on a market or something like that. Yeah, so the majority would be probably tied to those type of groups.
A category that you could
Yeah,
define.
yeah.
Okay. So the most recent tariffs that you just recently updated your tariff the beginning of this year, and that's
2022.
well, actually the version we just received I think was effective January of 2023.
Correct. We just filed one at the end of November, effective
Right.
January 1st,
Yeah.
2022.
So that one followed up on the version from the prior year where you, as far as we could tell, looking back at our records, it was the first time that Roberts had included the range of 0 to 50 for commission and 0 to 100% for discounts. Are we getting that right in terms of the history?
Yeah, I think we kind of like adjusted it in the prior year, 2022. Yes.
Okay, so before that, that range of discounting and commissions was not part of your tariff. Is that right?
Correct.
Okay. And is it your testimony that you are including it in your tariff last year and continuing this year because you need additional flexibility? That's what you're telling us?
Yes.
I'd like to look with you. Do you have with you the language of HRS 271-21, the primary statute?
No, I don't
issue?
have that.
Okay. I can read you a relevant part of it, and it's subsection B of that statute. So the statute itself talks about what common carriers can and cannot do in terms of collecting the compensation. And I'll just read a couple of portions of it. So no common carrier by motor vehicle shall charge or demand or collect or receive a greater or less or different compensation for transportation or any service in connection therewith, skipping a little bit, than the rates, fares, and charges specified in the tariffs in effect at the time. So doesn't that language seem to say that the carrier is not supposed to discount the rates that are specified in the tariff?
Well, I think in general, it's always been commission discounts have been part of the tariff structure. So, I think, from when you look at that, that means if you take that verbatim, then every single, historical rate or net rate that was out there was improper. So I don't think, like a plain reading of that necessarily matches up with reality.
Could another potential reasonable way to look at it be that it might be okay to discount as long as the tariff specifies the amount of the discount?
Well, I think whatever is in the tariff of the individual company that's filed would be applicable to discount, so if it's a range, it's a range. If it's a set amount, it's a set amount.
But do you think that a range is specific enough? I mean, if I continue to read the language of this part of the statute, there's a lot of references to specificity, right? And other parts of the statute and the admin rules talk about that tariffs have to be in dollars, in U.S. dollar currency. It's very specific rather than vague or a range. So I guess I'm trying to understand from you what if your position really is that you think a range is specific enough, or perhaps it might actually be required by the statute for a discount, if it were to be provided, to be a specific discount, like a 10% comma INA, that kind of thing.
Yeah, my position and everything that I've been stating is that I believe that a range is appropriate. And, you have to put it in place with today's environment. Like it's not 60 years ago when things were a lot different. We've got so many changes in the operating environment that we're all facing. So I think that's where the real decision is being made is, are the regulated companies being placed under an additional requirement that hinders and handcuffs them to be competitive against, all these other transportation providers out there that are not regulated. In certain cases, maybe they should be.
Okay. But ultimately, the commission has to follow the law as it's written today, right? We can't change the law without going into rulemaking or doing something else that would create a more flexible environment. Would you agree with that?
Well, I don't necessarily, it doesn't prohibit a flexibility, so I think, you can look at it that way too.
Okay. All right. Thank you. One question for the consumer advocate, and then we can move on to Commissioner Kawai. So you mentioned that you felt the issue of range of discounts or reasonableness of discounting could be dealt with on a case-by-case basis, and there wasn't necessarily anything to be done in this docket on that issue. And is that your position, that the concern raised about the large range of Roberts discounting is not something that the commission should specifically seek to address or decide in this proceeding, and instead look at it perhaps in another proceeding? Or can you clarify your position on that?
Yeah, I think that's correct, Commissioner Rios, and thank you for the question. And kind of tying it back to the earlier line of questioning about whether a specific amount is more in line with 271.21B or not. Is in line with HRS 271-21B as in Bravo. You can imagine a scenario where a specified discounted rate of, let's say, 40% could lead to anti-competitive pricing, depending on how it's applied and depending upon that specific entity's business operations. On the same hand, a entity with a range from, let's say, 1 to 50 or 1 to 40 might not have those same anti-competitive concerns when you look at the data and the underlying issues, as well as, the marginal cost, things that we've cited to in our briefs. So it's those specific issues that haven't been presented in the record in this docket that the division would be concerned about.
Okay, and then one follow-up question to that. What about the value inherent in specificity of providing public notice? Is there a reason that this commission should consider taking some action now regarding the issue of whether a range of discounting is adequate or lawful, as opposed to a more specific discount that provides public notice as to, what the discounted rate actually is?
So I'm trying to understand that question from the perspective of a customer who's trying to solicit services, and whether or not a filed rate has a range or a specific amount. I would argue they would be on notice of either of those things. And in a competitive market, they would also be able to solicit multiple competitors' bids or pricing for the same or similar service. So I think in a competitive, specific to this set of circumstances where you have a competitive market, that's how those concerns are better addressed, would be the argument we would put forth.
Okay, so just a quick example then, I'll just make up a hypothetical. A customer approaches a carrier and that carrier has a rate of $87 an hour, just hypothetically, and a discount range between 20 and 40%. And the customer actually asks for service and or is given a discount that's within that range. At that point, the customer knows what the exact amount is. So they decide to proceed or not proceed hiring that carrier. And you're saying that that's similar from a public notice perspective as a carrier that has a specified rate of 10% for Kama'aina, and I go in there, show my Hawaii driver's license, and I know that I'm going to get 10% off $87. You're saying those things are equivalent, or is there any difference between those two hypotheticals?
I think there's a difference, but once you receive that final price, you'll have knowledge of what it is that would be charged to you, and you would have the ability to, as you mentioned, Commissioner, look to another competitor to see what discounts they may or may not offer and get their pricing as well. And with that, you would have the choice at that point to retain whomever's service under that situation.
Okay, and I'm going to steal a little bit of Commissioner Kawai's thunder here, but by even mentioning the filed rate doctrine. But the filed rate doctrine is sort of a public notice concept, right? It doesn't presume that someone will go in and do further follow-up and find out more specifics. It allows the public to compare rates from afar simply by looking at the posted rate, the filed rate. So if from that perspective, it's not equivalent, I guess, right? Because if you presume there's no follow-up, the customer who can look at the filed rate and see a 10% discount immediately knows what the amount is that will be charged. If the customer looks at the other carrier and they've got a 0 to 50% rate, they know it's going to be somewhere in that range, but they don't know how much until they follow up. I guess that's the question. Like, is there a filed rate doctrine problem with the difference between those two scenarios?
I'm not sure that there is, and I'd also say that I think the issue presented is not that specific either. I think the argument being made is whether or not that it's a guaranteed discount, but that it's a specified amount needs to be included in a tariff. And if you were to provide that range where you might have a bit of uncertainty, that somehow runs afoul of this commission's ability to regulate this market. So I think it's a not as of a specific of an issue being presented, I would argue.
Okay, I have no further questions for right now.
Thank you, Commissioner Yost. Commissioner Kawai?
Mr. Boone, I want to follow up on your responses to Commissioner Yost. You're basically saying that a customer can basically shop around and then decide which carrier it wants to go with, correct? That's your position. And you're saying that does not run afoul of the foul rate doctrine, correct?
That is what I'm saying under these set of circumstances.
Okay, but isn't it possible that if you're contracting with a large enough company, let's say, because those are probably the companies that are going to be shopping around, would that classify you into a private motor carrier?
I'm not sure, Commissioner, I understand the,
Well, in other words, if you're entering into a contract with a third-party customer, and this customer is giving you so much business that you want to give them a special rate that's not articulated in your tariff, can't you avail yourself of the private common carrier provisions and petition this court or this commission to qualify you as such?
I'm not aware of that area. I'm happy to provide supplemental briefing on it, but I can't answer that.
So what the commission is struggling with right now is we're very sympathetic to all common carriers at this point. We understand that it's a tough market out there, and we want to provide as much flexibility as possible. But you and Western raised some very good legal arguments as to why we need to stay with the filed rate doctrine. The problem is the filed rate doctrine, if strictly interpreted based on your briefs, doesn't give us very much flexibility to give any type of discounts or ranges or commissions. So that's what we're struggling with. So that would affect, for example, some of your membership. And obviously, we don't want to necessarily affect all mom and pops. That's not fair. We want to be as flexible as possible and be fair to the public, not to each other, to the public as to what each carrier is offering. So we're struggling right now to balance the interest of the public with the interest of the carrier and their profitability to survive in this tough market. So let me move on to that now that I've raised that. And yes, I would appreciate some supplemental briefing on that. Western, in your opening brief, you mentioned that any allowed commission or discount should not be allowed as a range. Given what I just discussed, is that your membership's position that
Yes.
and there shouldn't be any ranges given the fact that there is a filed rate doctrine out there?
That's correct. Because essentially what happens is that two customers can go to the same carrier and get different rates set under a wide range. And customer A won't know what customer B is getting. So it's not as if a customer can go into a carrier and then negotiate a range and then that person is informed. That doesn't inform the general public. Our position is discounts are all right, but the discounts have to be stated for each particular circumstance so that the general public knows, like you said, the Kama'aina rate is 10% or whatever, or if you're a large customer, you get this commission rate, you know, within.
But then you come into play with the zone of reasonableness, right?
Yes.
Isn't it?
Oh,
Sorry, then the zone of reasonableness comes into play.
Yeah,
So you're allowed as
yeah, that's right, the zone of reasonableness. But when you have a potential discount of 0 to 100%,
I'm
you
not
know,
worried about that.
yeah,
Forget about that
okay,
aspect of it. Okay. Zone of reasonableness comes into play, and let's say we are authorizing 10%.
sure.
Okay. So is the public adequately informed because we're giving a range?
Yeah, well, that's a small range. That's why I
So
said
you're
in my
not
brief, a
objecting
large.
to the range.
No,
You're objecting.
we're objecting to a large range.
Okay.
That's what
I
we're
just want to
saying.
clarify
Yeah,
your position.
yes.
Okay. Also, you filed a letter back in January 28th of 2022, correct?
Yes,
And you raised some issues with respect to two other motor carriers' tariffs.
that was done by our general manager, yes.
Okay.
Well, one of them was whether the tariff was in the proper format. The argument was that the formatting is not what the Hawaii administrative rules calls for as a sample tariff.
And
That
under what basis did your general manager file that letter?
That she was concerned that a tariff was granted that wasn't in,
But isn't there a provision under the administrative rules that allows her to file protest to that tariff and the form of the tariff?
yes,
Okay, so you're on one hand saying that there are these administrative rules that someone failed to follow, but on the other hand, you're not following the administrative rules.
well, I guess that is a technical issue that the tariff did not,
Well, it's a technical
Yeah,
issue that you kept raising over and over again in your letters to the commission or to the commission staff and to third parties. And in reviewing the letters to the commission as well as our responses, we made it very clear that this issue would have been addressed in docket, the instant docket. But yet in the instant docket, you folks never raised the issue of discounts and commissions during the earlier proceedings in your briefs.
we did raise the issue of discounts and proceeding in our opening brief and in the letter of January last year.
Yeah, but
That was the main issue. The other one was a technical, a smaller issue that, wasn't that much of a concern because it didn't affect necessarily other members of the WMTB.
so were you filing protests? Is that what was the intent of the letter?
It was basically a question is how did the commission grant this particular tariff?
Under
With
what
this-
statutory authority did your client have to file that particular letter for which the commission was required to respond?
I guess the Hawaii administrative rules
Which provision of the Hawaii administrative rules?
that we could challenge a tariff
Okay,
that didn't seem to be fair and just.
okay, and isn't there timely or time requirements and process and procedures for filing that?
That's correct.
Okay, so the time in which you filed your protest, let's say was that timely? And did you follow the process and procedures?
No, it wasn't.
Okay. Now
But
let's.
if they filed
no, wait,
another one
Let's just stop right,
this year-
let's stop right there, okay?
Yeah.
Because you're ahead right now.
Okay.
Okay. So you acknowledge that the issues that were raised by your client does not fall into the category of a protest.
Protest, that's correct.
And that the commission therefore was not required or obligated to respond to that letter.
That's correct.
Okay.
But you should have responded by saying you're outside the time limit.
We-
Rather than not respond at all, which is what the commission did. They
Well-
didn't respond.
I beg to differ. There are several correspondence in the record that basically said that that we were examining it as part of docket. And if you
This
take-
docket, yes.
Yes. So,
But that
but
was
yet-
late.
sorry.
This order came, I think, in October.
No, actually, there was a letter back in May that indicated that your communication to us, that we were handling that particular issue as part of the docket and that the communication constituted ex parte contact.
Okay.
So we made it very clear that we were going to address this issue as part of this docket.
Okay.
And that, first of all, I would like to remind your client that if they have an issue with the tariff, to please follow the process and procedures and file a protest. That would give us a better time heads up, rather
Okay.
than raising it after the fact. We appreciate the fact that you raised these issues and brought it to our attention. It's just that we would appreciate it that if you follow the process and
Okay, fine.
procedures.
I'll so advise them.
One last question. In June and in your opening brief, you took the position that 10% was a reasonable range of a zone of reasonableness. And you provided a really good analysis of why 5 to 10% was reasonable. Do you have anything to support the 15%?
Well-
Other than
Well,
What's in
what
your-
happened was that when the consumer advocacy filed their brief and we went back to the membership, there was a hue and cry saying, oh, we want more, we want the 15%. So basically we have to listen to our membership. In other words, the board initially said, let's not have an extension. And then this issue came up to the general membership. So we pulled the membership. We had various meetings, and it turns out that a large percentage of the membership wanted an extension. So we basically have to follow their lead. In other words, the board can say, well, legally, we think that there shouldn't be an extension. But then when the membership comes to the board and says, no, we want an extension, you know, the president decided, I guess we will just go along with an extension.
Okay.
It's a political issue.
Okay, thank you for your clarification.
I just had a couple of questions. And this is actually to all, I mean, and it's around the zone of reasonableness. Right, I was around when the gas prices spiked. That was the beginning of the discussion, and this was even with the legislature. Right, and we had to do something, and one was, right, looking at the zone of reasonableness. That's why we went from 10 to 15. And what I'm hearing today from everyone is that it should be extended, right? Because we see it out there, right? Prices haven't really come down as fast as we would like. But then my question is, right, I think, and this is something maybe you folks might have to brief, because you might have to take a look, because one of our evaluations on even extending is is the percentage correct, right? And we set that forth, right, when we put in the temporary, right, that we will also look at whether or not the percentage is right. From what I'm hearing, looks like 15 works, but right, I don't know, right, you might have to poll your members, because we're not hearing it either, right? Maybe it's because gas prices came down a little bit. Maybe it's other things, right? But we just need to know that information, right? Not so much extending it, but whether or not the percentage is at the right percentage, right? And don't take this as open season to go 2025, right? I mean, really take a look at it, because you guys know your members, right? Roy, you know your business better than us, right? We're trying to and that's around, right, this air of flexibility, right? I think we all can agree that we want to try to provide some flexibility, right? At the same time, we struggle with, right, laws from 1961, right, that are not kind. So, right, that's that side of the spectrum where we need to work on the laws, right? Like Commissioner Yo said, right, that means taking it to the legislature. That means kind, right? And that to be is more of the industry needs to help drive that, right? How do we make the motor carrier rules and, well, the laws first, and then the rules will follow, right? How do we make it more modern, more, I mean, that's my comment. But, you know, let me get to one. I want to make sure I understand what Mr. Boone was describing. We're talking around, like, on one hand, right, the notice of rates, right, specific is better than a range. Is that your argument, basically, in a nutshell? Or is it, so long that everyone understands how, say, a range might work, right, is that adequate notice to the public, to the consumer?
I think we would argue under the filed rate doctrine, as long as the range is filed as part of the tariff and approved, then it's sufficient, in conjunction with, of course, the applicable statutes and administrative rules that apply. And then what we're, I guess, suggesting that the commission look at is it's not focusing on whether, this issue of is there a range or not. It's what is that affecting, or what is the concern that we're looking at. And the concern that's been identified by WMTB that, we're sympathetic toward is the potential for predatory pricing, or for a entity to drive down its prices to eliminate competition and then eventually hike prices back up. And so absent that, evidence of that occurring, there really is no need for the commission to go beyond what it's already doing as far as how it's regulating these discounted ranges, or these ranges of discounts.
Okay. And I'll open it up to any comments on my comment earlier. Mr. Kunib.
WMTB is a nonprofit organization, and we're barred from trying to lobby with the legislature. But
That's
we have
fine.
We have some good ideas that we wish we could, but we can't jeopardize our nonprofit status by doing anything political, anywhere close to that. But we hope that, like the HTA, somebody else can take the lead.
Well,
and do these-
I'm looking at it, right, as the industry, not so much you guys. I mean, somehow you guys will be part of that discussion, maybe not at the ledge, but certainly within the industry, right? I think that's how I picture it, right? We're here, right? I don't know who I had the discussion with, right? When this whole thing about, right, what do we do with, spiking gas prices, right? And I get it, right? And then at that time, it was only a few motor carriers, right? And was small mom and pop guys kind of saying, we need some relief, right? And when I talked to someone and I said, you know what, we need to do it for the industry. We can't just do it for the one-off, because we're going to have 1,500 motor carriers coming to us and asking for relief, right? So when I say the industry, right, you guys are part of it. Where you have that discussion, that's up to the industry, right? I hope that you can be a part of that discussion, right? As we talk about how do we, I use the word modernize, but it's really bringing these antiquated laws and rules more up to speed with today, right? That's one of the things, and it might be a long-term thing. So then, in terms of that, what are interim steps we might have to take, right? Because, right, I'm on that side, right? I'm on the side of we gotta try to really keep our economy going, right? And that includes everybody. So how we do that yet to be determined, but granted, right? You guys are a nonprofit, right? We know that, but I hope you still can be a part of the discussion. You and your members, right, can be a part of the discussion. Maybe not lead it or whatever, but just be a part of the discussion. Any other commentary, Mr. Fun?
Yeah, just on that legislative side, we've been over the last several years, we've been actually trying to get the legislator to include the TNCs, the transportation network companies, the Ubers and the Lyfts, as some kind of regulated company. The individual workers, we think that they actually should fall more under PUC because, they are, even though they claim that they're not, they're little independent business operators, and they're, they got a fare, they're running a business. So, it's gone really nowhere. The industry itself, the TNCs, they want to basically create a third category. So you have your PUC regulated entities, you have your taxis, and then the TNCs want to be a third entity or group of companies that basically have no regulation. Their intent is to separate themselves from the PUC and the county taxi regulations and be a third non-regulated activity. So, it's kind of been going back and forth all these years, but, we haven't been too successful in getting them regulated, because they are actually true transportation service providers. So anyway, just comment there. Thank you.
Mr. Fun, do you know of any state that regulates the Ubers and the Lyfts? And
Yeah, just in general, there's been much more regulation. Like, I think California at one time, they were trying to even force the drivers to be considered employees.
Right.
And then I think New York is also really taking a lead in trying to regulate their business activities.
but
So,
they're not, it's not regulated under the Public Utilities Commission. It's, I think,
Yeah.
different aspects to put controls on the.
yeah, because they're basically, they're really competitive because they have no benefits. They don't pay the taxes, and they're not following all the Hawaii-based regulations that companies that are operating have to face. So we have like two totally different operating structures and cost structures.
Okay, I think that's all the questions that the commission has. So members of the public. So Gareth, HTA.
Thank you, Chair Assumption, Commissioner Kuai, and Commissioner Yost. Gareth Sakakita, Hawaii Transportation Association. Boy, this is the one time I wish I brought a coat to wear.
Sorry,
No,
Central Ale.
no, I'm getting old too,
The thing
boys.
is on the lock and key too, the temperature.
That I
Tags,
understand.
it's tags.
Well, the only item I can really speak to is number 5, the more boring one seems. Although I advanced all the questions to the members, I didn't receive any responses to the other items besides number 5. So the 15% was supported. We that triggered our queries back in March about primarily the fuel increases. And my only comment now, because you have my comments from November, the only additional comment is that although there's talk about fuel stabilization, fuel price stabilizations, and even reductions, especially on the mainland, they've ranged, well, all over the place. But in Hawaii, gasoline prices have vacillated about 3 to 4 cents over the past, well, since last fall. But not diesel. Diesel does vacillate, but when you look at the current average versus last month's current average, it's the same. So, and then that's where most of our members, that's where their concerns lie with the diesel. Gasoline, yeah, there are operators that use gasoline, but this our heavy equipment is primarily diesel. And really, that's the only comment I have.
Thank you.
Thank you.
With that, I'm going to, I'm gonna ask for brief
Yes.
by when.
We'll follow up with an order because we need to
Okay.
make sure that everyone's on the same page.
Okay, so what we will do is we will ask for any final briefs, right? Especially if you needed to update items that were asked of today. But then we'll send out an order giving you the deadline for that. And we'll give you time. We won't like spring it on you and give you only like a week or something, but we will send something out. Okay. So with that, the commission will take into consideration all of the briefs that have been filed, today's arguments, and also the public comment from the HTA, including anyone that comes in the interim. And those are all viewable on our DMS, right? We do file them into the docket, right? So we have it all in one place. And we'll take all of those into consideration. And the process will conclude with the commission's issuance of its written decision and and that comes after, right, the final briefs that we're gonna ask for. All right, so that concludes today's hearing. Thank you again, everyone, for spending your afternoon. We get to go to the legislature. Our budget is on tap right now. That's why Dean had to leave. Off the record. Thank you. And with that, we are adjourned. Thank you.
Thank you, everyone, for coming.
Sorry. Yeah.
Closing briefs and then